Hey guys, this is Hearn-Rushton, attorney and law partner with the Rushton Law Firm in Nashville, Tennessee, and I am here today to talk to you about a topic that's pretty popular when we have consultations with new clients regarding divorce. And that topic is who is going to pay all of these attorney's fees and costs for our divorce action? Have you ever wondered that? It's pretty well known fact that anytime that you are dealing with a divorce action, somebody's going to have to pay attorney's fees and court costs and all those types of costs in litigating the divorce. And so a lot of litigants get involved in divorce actions and they're trying to figure out, well, who's going to pay for all of this? It's expensive. Attorney's fees are costly and so on. Now, I will tell you a couple of things that you need to be aware of. Number one, most divorce actions are handled by attorneys on an hourly basis. They're not generally handled on a fixed fee structure as, say for instance, you pay me $3,000 and I'll divorce you. That's not very often the way that divorces are handled in Tennessee. Although it can be that way, it's not something that happens very often. And number two, divorce actions are never handled or should not be handled on a contingency basis. That is unethical for an attorney to take a divorce action on a contingency basis in Tennessee. In other words, I'll take your divorce action and you don't pay me anything up front, and then if I get you the house and the car and the bank accounts, you give me a percentage of that. Well, that's a big no-no. That's unethical. That's not something that an attorney can or is allowed to do under Tennessee law, and so keep that in mind if that ever comes up. That is not an ethical thing to do. So we go back to the issue of who's going to pay all these attorney's fees that are piling up in my divorce, because my divorce is extremely complex. We've got children, we've got potential for alimony issues here. We've got someone maybe that's out of work or someone that's earning a whole lot of money, or there's questions about whether something's separate property versus marital property, and maybe we've got business assets that we've got to also conduct valuations on, and expert fees and so on and so forth. And so the way that works in Tennessee is we're under what's called the American rule. The American rule is that litigants to an action, a civil action, are responsible for their own attorney's fees with a couple of exceptions. And number one is the first exception is if you have a contract of some sort, and in a divorce that could be a prenuptial agreement that says that one party or the other is going to cover the attorney's fees for the other party. Well, then that could be potentially a contract that allows for you, if you're the one that's trying to recover your attorney's fees, to recover those attorney's fees under that contractual basis. Same thing with a civil action of some sort where you've got, say, a breach of contract, and the contract says that the prevailing party shall be awarded their attorney's fees, if this thing goes to court and they win. So it's the same difference. Also, in Tennessee, under the American rule, we have a provision of that says that you can't actually recover your attorney's fees unless there's a statute that allows for the recovery of those attorney's fees. And so that's generally where we see more attorney's fee awards, or how the court determines the legality of awarding attorney's fees to one party or the other, or splitting it down the middle, or otherwise how to handle it. And that is under Tennessee law, we actually have a couple of statutes that deal with attorney's fees in divorce, and then there's a separate statute that deals with attorney's fees in, let's say, post-divorce actions dealing with child custody. And so those are statutory, and it says basically that the judge has wide discretion in awarding those fees and those costs in a divorce action. And so that's where this segment of our video comes in, and that is, who's going to pay for all these fees? This is a lot of money. We've got a lot of attorney's fees stacking up, and I don't know if I'm going to have to pay them, or if my spouse is going to have to pay them, or just how that works. Well, here's the way it works. Generally, the court's going to look, if you go to trial on a case, the court's going to look to determine if there is a financially advantaged spouse. Let's say the husband earns $2 million a year and the wife's always been a homemaker. And, post-divorce, it appears that the husband is going to have, let's say, major separate assets left over from a business or otherwise that he would have access to. And so the wife, let's say, is the disadvantaged spouse in this instance, or in this scenario. Well, then there's a good chance that the husband's going to probably end up having to pay the attorney's fees for the wife and for himself. Likewise, there's a couple of other things that the court can consider in that. It's not just the ability of the parties to pay. There's also the potential for the court looking not only to the post-divorce financial circumstances, but sometimes we have situations where we have inappropriate marital conduct by a party, or we have, let's say, adultery by a party. And let's say, for instance, in the scenario where we have inappropriate marital conduct or adultery, where one party's been cheating on the other party, and the first party alleges in their complaint that there's been cheating by that other spouse, and the other spouse denies it. They say, no, I haven't been doing it. You just need to prove it. Well, sometimes that comes up, and then sometimes that original spouse that raised that issue in their complaint does prove it. Maybe they have to hire private investigators. Maybe they have to spend a lot of money on their attorney's fees for the attorney to conduct depositions of a paramour, depositions of the party that's at fault or otherwise, and they finally do build the evidence for that particular case because the number two spouse just won't admit it, or the defendant won't admit that they have done the thing that's a ground for divorce, and the first spouse has to prove it. Well, if that happens, there's a good chance that the number two spouse there, the one that has been alleged to have been guilty of the inappropriate marital conduct or the adulterous affair, is probably going to end up stuck paying the attorney's fees and the investigative costs and so on of the other party because they have concealed it and they have moved forward on not coming clean on it, so to speak. So that is something that can play into a factor at trial or otherwise as to who's going to pay those attorney's fees of that spouse, that innocent spouse that's having to determine that their spouse has been involved in inappropriate marital conduct or in some form of adultery or otherwise. So that's another case where, scenario where we might see an award of attorney's fees to a spouse. Now, there's other situations that I've seen at trial. I've had it come up at trial before where, let's say, we have one party that's alleging that the other party is guilty of inappropriate marital conduct, okay, and they've asked for their attorney's fees, and they've said, hey, you know what, he or she did X, Y, and Z, and it hurt my feelings really bad, and it wasn't really good for our marriage, and therefore that has caused the demise of our marriage, and so I'm going to trial and I'm going to prove it. And let's say they go to trial and they do prove it. But let's say also that other defendant, that other party, shows up to trial and says, well, you know what? I think that my spouse was just as guilty of a similar inappropriate marital conduct act or acts, and therefore I'm going to prove that at trial. And if I do prove it at trial, then I'm going to ask for them to pay my attorney's fees. And so let's say we go to trial and they both prove that the other was wrong. The other had done some significant things that were deemed to be inappropriate marital conduct. And let's say the court then looks to their financial assets and determines that they both have enough in the way of financial assets to cover their attorney's fees and cost. And the court simply says, you know what, I'm going to pronounce you both divorced. I'm going to find you're both guilty of inappropriate marital conduct, and you both get to pay your own attorney's fees. So sometimes that happens. Sometimes we have very, very contentious divorces that go to trial, and very wise judges hear these cases, and they have a lot of experience, and they see what's going on, and they realize that, well, they can both afford their own attorney's fees, and that's the way it ends up shaking out. So anyway, the bottom line here is the court will look to the assets of the parties and will determine, if one party or the other can better afford the attorney's fees of both parties. If that's the case, then the court might use their discretion and order those attorney's fees to be paid by one party for the other party because they are in a better position to be able to pay that. That may be due to the mental condition of a party, one being sharper and the other having some sort of diagnosed mental condition or physical condition of a party where one is disadvantaged to the other. That could be because of, like I said, the financial condition of the parties post-divorce, what it's going to look like post-divorce. And that comes in sometimes where you have one spouse that's, let's say, has a significant separate property that they brought into a marriage, and it's a short-term marriage, and the other party doesn't have very much. And so at the conclusion of the divorce, the court determines that the party that came into the marriage that was disadvantaged and did not have nearly as much as the other party may just not be able to afford to pay all those fees and costs, and the court could order that advantage party to pay that. And so that's another factor. So, mental condition, physical condition, financial condition, somewhat fault, that could go either way, but it really comes down to the sound discretion of the trial judge. You have to realize trial judges in Tennessee have a very wide discretion level, and they can make a lot of decisions that sometimes seem to be harsh, sometimes are very helpful for one party or the other, and sometimes it just comes down to the facts of the case. So keep in mind that if this is a situation that you're going into and you have questions about this, find a qualified attorney in your area that has some experience in domestic relations cases. Talk to them about your specific facts of your case, and go over what you think is important and what that attorney thinks is important, because every case is a little bit different. Every case has factual information that might make a difference one way or the other. And of course, I don't think you're going to find any attorney that's going to be able to guarantee a result, because that would not be ethical either. But just know that these are some of the factors that we see in how attorneys' fee awards are made in divorce cases in Tennessee. Hope this has been helpful for you. Let me know if we can help you. Certainly you can visit our website at therushtonlawfirm.com. We'll be glad to give you a 30-minute free consultation if you are looking at filing for divorce here in Tennessee, especially in the Middle Tennessee area, or if you have other types of civil litigation that you might need help with. We also handle other general matters, especially construction litigation, and also contract disputes and business matters. So thank you so much for tuning in today. Be sure and like and subscribe the video below, and do not hesitate to email us or leave a comment below if you have any questions. Thanks, and take care and have a good week.